Hello friends, welcome to the channel All in One for You. First of all, subscribe my channel for more English and Punjabi shorthand dictations.
The court, while merely passing an order for withdrawal, is deemed to have passed an order only on the basis of what was contended by the parties, namely of the tenant's objection regarding the premature filing of the petition and the non-maintainability of such a petition, and the landlord acted on such an objection and sought for withdrawal. It is not a case where the landlord has sought for a liberty which was refused by the court. On the other hand, it was an action of the landlord in responding to an objection about the maintainability as stated by the tenant. The provisions of Order 23 itself is raised on a principle of public policy that a defendant shall not be vexed with the same nature of suit again and again. It is indeed a provision to protect a defendant, but if a defendant had himself invited a second petition by his objection that the earlier petition was premature or not maintainable, he cannot be heard to contend that the second petition was also not maintainable. It will be really a case of estoppel operating against the defendant to contend that the second petition was barred. I therefore reject the contention raised on behalf of the tenant that the subsequent petitions were not maintainable. The argument that no permission was granted by the court is also without any basis, as in Lal Singh versus Ajit Singh and another 2008, this court has held that where a application has been made and the statement of withdrawal is there to file on the same cause of action, permission to file fresh petition would be deemed to be there. Relevant observations reads as under. Admittedly, the application moved by the plaintiff is on record as XPW6, which contains not only the prayer to withdraw the suit but also to file fresh suit on the same cause of action. It is true that while passing the order, the sub-judge first class Tarantaran has recorded the statement of the learned counsel for the plaintiff on 1985 and dismissed the suit as withdrawn and did not advert to the second prayer. But in Surjan Singh's case, Supra, a similar order was passed which reads that in view of the statement of learned counsel for the plaintiffs, the suit is dismissed as withdrawn with no order as to costs. File be consigned.